Glinius. Oh, now it's being recorded. My name's Joe Glinius. I'm a partner in the St. Louis office of Husch Blackwell. My particular focus is in labor and employment matters, which is wildly irrelevant to you today. So congratulations, you're not going to hear about my day today. But I'm sitting here for a couple of reasons. One, I'm one of the attorneys here who manages our relationship with Honeywell. And two, I'm going to be our next chair of the firm, effective not until April 1st. So until then, I get to just pretend to be a lawyer for a little while. But I wanted to take the opportunity to introduce our team because our relationship with Honeywell is so important to this law firm. It's been so gratifying. You have lots of client relationships as an outside attorney, and they're all wonderful, and I mean that sincerely. But there's something even more gratifying when you're working with people who think the same way you think, share the judgment you share, have the same temperament. And that's been the great experience we've had with Honeywell. So we're very thankful and feel very privileged to have that. So thank you for that, and thank you for allowing us to chat with you today. With no further ado, I do want to introduce our speakers today by way of a little bit talking about the group. So Husch Blackwell's International Trade and Supply Chain team works with clients to manage the challenges inherent in the globalization of supply chains. Our ever-growing team currently consists of 19 attorneys dedicated to international trade law. Many have substantial practical knowledge gained from serving on key federal regulatory agencies themselves, courts, and congressional committees. With deep expertise in international trade remedies, customs, forced labor, export controls, economic sanctions, and Section 13 or 337 matters. This team has incredible expertise and insight that we're thrilled to share with Honeywell today. As such, it's my pleasure to introduce my partners, Courtney Morgan and Grant Leach, each of whom are key leaders of our international trade team. And so, Courtney, you want to take it off from here?
Sure. Thanks, Joe. And we're very excited for what the future brings for Husch Blackwell and for you. So thanks for that kind introduction. And we're very excited to get a chance to present to you to Honeywell today. Grant and I have both had an opportunity to work with Honeywell a bit before on the export controls and sanctions side, but we're excited to provide you with an overview of 2023 developments on both the import and export side. Just by way of background, I'm a partner in the DC office. We're spread out across the firm. I joined the firm in 2014, and I currently lead our international trade and supply chain practice. We've grown a lot in the last few years, and I'm very proud of that. And we really cover the whole supply chain. My specific practice is export controls and sanctions, but I do also do a fair amount of import regulatory work and import enforcement work. Because I actually spent my first 14 years of practice at a trade boutique where I dealt with all types of different trade issues. I don't get as much involved into the anti-dumping and countervailing world, but I know enough about it to spot those issues and help you with those if you have them. But we have very capable partners that have a lot of experience in that area. So I'm going to get us started. A couple of housekeeping matters. If you could please make sure to mute yourself, and you want to make sure that your screen name matches the name you registered under. I know we have some people joining, and so as you join, just make sure your name is correct because we're recording for CLE purposes. For questions, we welcome questions and welcome them throughout the presentation. So please use the chat feature and do your chat to everyone, or use the raise hand feature, and we'll be monitoring that. A PDF of this program, because there's a lot of information, will be sent to you tomorrow by email. So look for that. And finally, the program is approved for CLE hours. An email will be sent to you tomorrow with the certificate of attendance. Sign in for CLE and a program survey and a copy of the recording. So with that, we split the presentation. I'm going to cover import developments, and then Grant is going to take it away and cover export developments. And he's going to introduce himself then, so I'll kick us off. So first, I wanted to start with a little bit, all of you probably have some familiarity, my guess is, with the world of trade remedies, but just in case, we thought it might be nice to go over it a little bit. So anti-dumping and countervailing duties. There's two types, anti-dumping and we often call them AD/CVD, investigations and cases. In the anti-dumping world, dumping is defined as selling goods at prices in the US at a price below that charged in the home market. So that's the domestic market of the producer. These dumped imports may cause or threaten to cause material injury to the United States domestic industry. So those domestic industry players will get together and file a complaint. The investigations are company and country specific. They're unique, and it's a unique and complex type of litigation before two government agencies, before the International Trade Commission and the Department of Commerce, which are both here in Washington, D.C. The cases are really unique because they have super tight deadlines, a lot of requests, very voluminous requests, data reporting requirements where you're giving information on home sales and home market sales and U.S. sales. So they can be very data intensive. Looking at those versus countervailing cases, countervailing subsidies are financial contributions made by a foreign government authority, which confer a benefit to the party, to the manufacturing entity that allows the entity to produce more goods or export more goods to increase their market share. CVD investigations are country specific, and the duties are calculated to duplicate the value of the subsidy and to offset the injury. Similar to AD investigations, they're very short in time frame. They usually involve foreign government representation. You'll have foreign government officials usually speak at those hearings, but very similar time frame and very data intensive. That's just some background. In terms of current AD and CVD orders in effect, there are 669 active orders, 494 are anti-dumping orders, 175 are countervailing duty orders. This is just a little bit of the breakdown of the types of products covered. So steel and steel related products, those are most heavily represented with 305 cases. Chemical products, 87 cases, other metals and articles of metal, and then plastics and rubber. In terms of AD 2023, it was really a remarkable year. After we had a dip in cases during the COVID years, the filing of new AD and CVD cases increased significantly. We had 81 new petitions filed in 2023, 12 against imports from China, 10 against India, 5 against Indonesia and Taiwan. So you can see through, this summary that the cases dipped quite a bit during the COVID years, but now have come back up to close to what, right at what we were in 2017. Some key developments to watch going forward in 2024 on anti-dumping and countervailing issues. There are regulations currently underway. There's an interagency process of review going on right now on proposed regulations to expand the enforcement authority for AD and CVD matters. We anticipate that those may come out later this fall, likely tied in potentially to the election as a potential talking point. So that's something to be on the lookout for. Next, Vietnam's market economy status. That's a question because of the rise of China and because of the rise of Vietnam as a second economy or an alternative to China. There's a question of whether market status will be currently Vietnam's considered a non-market economy, and so for AD cases and CVD cases, their calculations and they're viewed separately. And so there is talk about Vietnam becoming a market economy. So that would change sort of the landscape of anti-dumping and countervailing for Vietnam. Another item on the horizon and currently ongoing is the aluminum extrusions case. In October 2023, a group of U.S. petitioners filed a petition for the imposition of anti-dumping duties on aluminum extrusions from 15 different countries. That includes Colombia, Dominican Republic, Ecuador, India, Indonesia, Italy, Malaysia, Mexico, China, South Korea, Taiwan, Thailand, Turkey, the United Arab Emirates, and Vietnam. This case was after the original aluminum extrusions case against China, which you may very well know about. This new case was very targeted by the petitioners to include those additional countries to sort of target some of the transshipment and some of the goods that were moving out of China and going to these third countries, but also to expand the scope. The CBD petition for this case covers China, Indonesia, Mexico, and Turkey. And this is the second AD/CVD case brought against aluminum extrusions. The scope in the new case specifically includes a number of goods that incorporate aluminum extrusions, including downstream products and sub-assemblies that were previously excluded from the order against China. Some items to note: car and truck frames, motor vehicle parts, solar panel racking and framing, fence posts, consumer items that run the gamut, tent poles, door thresholds, heat sinks, and then electric vehicle charging station parts. So it's really, really an expansion of the scope. Many HTS numbers are covered or at least considered for the case. So it's ongoing right now. The preliminary determination will likely come out in March for CBD and May for the anti-dumping case. And then we expect the final determination this fall. Finally, solar panels. This is another growing area. Solar panels has been definitely an area of dispute. And it's also, in terms of the administration and the current government, in terms of moving more towards clean energy, it's been a very heavy focus for enforcement. So that's another area to keep in mind and to watch. Next, we wanted to touch on what we call UCLPA. If you're familiar with it, the Uyghur Forced Labor Prevention Act. These regulations or this statute went into effect in 2022. It was rolled out in 2021. Its purpose is to prevent the import of goods made with forced labor. It creates a rebuttable presumption that goods made whole or made in the Uyghur region, so the Xinjiang Uyghur Autonomous Region, are presumed to be made with forced labor. It's caused massive supply chain issues for many of our clients. We're dealing with, we've licensed various AI products where we're helping our clients map their supply chains, helping them respond to detentions. To date, some of the statistics in 2023, there were 4,000 different detained shipments, and 1 million or $1,429 million in goods have been stopped at the border. In terms of some of the targeted products to be concerned with, cotton, polysilicon, tomatoes, automotive and aerospace, pharmaceuticals, and metals. It's heightened focus on not just the raw materials, but intermediate components as well. CBP has detained goods shipped from countries outside of China in light of the prohibition against raw materials and intermediate components. We've definitely seen cases of CBP looking at third countries, looking at Malaysia, looking at Vietnam, looking at Thailand. So that's definitely an area of increasing enforcement and increasing focus for customs. This whole the UFLPA is enforced by customs, and so it's an area definitely to watch and on the uptick. In terms of the actual enforcement, there's a forced labor enforcement task force. Their purpose is to monitor enforcement of UFLPA. They also publish an entity list. All of this information is available. If you're not aware, it's available on Customs website. They actually do maintain the entity list, and they provide, rolling updates in terms of detentions, in terms of the amounts of value of detained shipments. And so that's in terms of how a company gets onto the entity list. The factors they look at is whether it's located in the Uyghur region using forced labor. Are they working with the government of Xinjiang in furtherance of forced labor? Are they exporting products with forced labor as described under UFLPA? Or are they sourcing materials from the Xinjiang region for forced labor schemes? Another area we wanted to touch on is CTPAT, or the Customs Trade Partnership Against Terrorism. This is not a new program. It's a program that Customs has had in place for a number of years. But recently, in the last year or so, they've updated their security criteria, specifically to focus on supply chain mapping. They've issued new codes of conduct. They have requirements for supplier training, non-compliance remediation plans, and best practices. So that's definitely an area that's up and coming. And for those, if Honeywell is CTPAT certified, you likely already know about this. But if not, this is new criteria. In terms of some technological developments, CBP has adopted a new dashboard. They now do monthly operational updates. They have regional alerts that they send through the dashboard, and they've updated their UPA strategy. Another area of focus for customs, customs and commerce for the last few years has been the Enforce and Protect Act of 2015, or EPA. EPA allows CBP, or Customs and Border Protection, to investigate whether a company or other entity has evaded anti-dumping and countervailing duties in an on-the-record investigation. So this really targets those third countries where goods may not, you have an anti-dumping order against China, perhaps, and goods are coming from third country regions, and based on petitions and information provided to customs, whether on their own or through a petitioner, they may, have information that goods are being transshipped through a third country and the origin really isn't changing. EPA is a multi-party, transparent administrative proceeding where parties can both participate and learn the outcome of the investigation. While we don't have specific data from CBP on the number of investigations, there's been a significant uptick in the last 2 years, and we expect that to continue in 2024. Some best practices for importers, given the current environment. We advise on maintaining documentation, vetting your foreign suppliers. This can be through, obviously, certifications, going to visit your suppliers, using different software that's out there to help you map your supply chain, and making sure to provide complete responses to customs, whether you do that on your own or with outside counsel, but definitely to do your homework and make sure that those responses are complete, because there may not be that many opportunities to respond or, to rebut a presumption. Another area is, they're called RASA. I like to call them RASA audits, risk analysis and survey assessments. So for those of you familiar with Customs Regulatory Audit Program, they used to conduct what were called focused assessments. Focused assessments would be an entire review of a company or of an importer and all of the aspects of customs compliance. So tariff classification, value, country of origin, marking, preferential treatment, all different things, anti-dumping, countervailing duty compliance. Customs has now moved to this risk assessment criteria or risk assessment approach, where they'll do a more targeted assessment and then sometimes open it up for a larger investigation or review. They do this by issuing questionnaires. You then have a back and forth, usually a conference, in-person conference with CBP. These can last, 1 day, but can be a couple days to a week. You then have follow-up questions, and then the outcome is whether you pass the audit. And if you don't pass the audit, then you get sent to a full audit, which it more closely aligns with a focused assessment. Customs believes that these RASA audits allow them to quickly and efficiently evaluate entities relative to a specific area or issue of special interest without CBP and the import community committing substantial time and resources. They can get very focused and then turn into a much larger and time-consuming audit. Next, the Customs Modernization Act. They are doing some work in terms of modernizing the 21st century customs framework. These are some of the target areas that we may see some developments over the next year or coming years. I have to admit that customs is, I think all of you probably know this, that deal with the import side of things, customs does not move quickly. This is a framework, but obviously they're looking at enhanced facilitation, seamless data sharing, increased visibility and accountability, timely and effective enforcement, and secure funding. We also wanted to touch quickly on some import developments, given your interest in Mexico and operations in Mexico. So we have an update on some import-related developments, customs developments for Mexico. Specifically, similar to the US, in February 2023, The Mexican government implemented regulations prohibiting forced labor and the import of goods made with forced labor. This took effect May 18th, 2023. In August 23, they imposed temporary import duties of up to 25% on 392 different HTS or tariff items. These include steel items, aluminum, chemical products, rubber, oils, and ceramics. Those duties went into effect August 16th and will stay in effect for the next 2 years until July 31st. And then in October, there was a decree issued temporarily restricting the import of 68 tariff items intended to combat illegal fuel mixtures. So those are some of the most recent developments. In terms of enforcement, what we've seen going into Mexico for many of our U.S. clients are dealing with more or increased enforcement by the Mexican government, whether it's on inbound transactions or whether it's supporting origin certificates. We've seen a definite uptick in producers being asked to support their USMCA, so US, Mexico, and Canada free trade agreement certifications, or maybe their old NAFTA certificates. NAFTA is the North American Free Trade Agreement and the predecessor to USMCA. So some sample questions for substantiating origin is to describe the goods subject to verification, to provide a very detailed production process of the goods so you can demonstrate that there's a shift in origin, and then also details on your inventory management process. Some of the documents required are bills of materials, underlying components, values for each of those, and then copy of the sales invoice and proof of payment, as well as documents supporting the declaration of the certificate of origin. We've definitely seen in the last probably 6 months to a year, a number of questions that our US clients are getting from their Mexican counterparts or maybe from their customer, where the customers are under investigation or under review by the Mexican government. So they're being asked to substantiate those origin certificates. Some emerging trends for Mexico. They became a top trading partner for the US in 2023. There's been more, I think, with the rise of duties on China and a heightened focus on especially the countries surrounding China and a lot of Asia. There's been more nearshoring to Mexico. There's been a rise in manufacturing. And finally, the Maquiladora program is still growing and going strong. So that's something that continues to grow and has been working well for the last 20 years or so. Do we have any questions? I haven't seen any. Okay, so I'm going to shift gears. That was all of our import developments. Grant's going to take over and talk to us about export controls and trade sanctions.
Thank you, Courtney.
Yep, I'm going to stop sharing, right?
Yes. Okay, is my screen visible now?
Yes.
All right, well, thank you, Courtney, and thank you everyone from Honeywell for taking some time out of your day to learn about international trade developments. My name is Grant Leach. I am a partner in the firm's Omaha office. I'm in the International Trade and Supply Chain Practice Group with Courtney, and my specialty area is export controls, ITAR export controls, EAR export controls, then also OFAC trade sanctions and the Foreign Corrupt Practices Act. I'm going to talk about some developments on the export side during 2023 and some things to look out for in 2024. As far as big enforcement trends during 2023, this first one in April of 2023, BIS adopted a new policy regarding voluntary self-disclosures. What's happened here is now voluntary self-disclosures are a little less voluntary. It used to be that submitting a voluntary self-disclosure could only help you, and BIS would consider that as a mitigating factor that they would use to reduce your penalties. Now, if an offender commits what BIS considers to be a significant export violation and fails to submit a voluntary self-disclosure, BIS will consider that an aggravating factor and will hold it against you. So if you fail to voluntarily self-disclose significant export violations, BIS could use that as a basis for imposing much higher penalties. We also saw from BIS In April of 2023, they imposed their largest ever civil penalty on Seagate Technology. This was a $300 million civil penalty, and the basis for this was that Seagate was manufacturing hard disk drives, completely foreign origin, completely outside of the US, but they were using US origin source code and technology to produce them and then sell them to Huawei. So what this does is this shows BIS is just incredibly fixated around enforcement on Huawei, around the Chinese semiconductor industry, and then also these foreign produced direct product rules. They were a real challenge, but BIS here was very willing to use them as the basis for this 300 million penalty. So as complicated as they are, BIS is very committed to using them for enforcement purposes. We also had some enforcement trends with OFAC. We have here a $30 million sanctions penalty against Wells Fargo Bank. This is only a selected group of some of the enforcement actions, but this enforcement action against Wells Fargo Bank just shows providing services to a third country, and if someone in that third country is going to then use your services to service Iran or SDNs or other embargoed recipients, that can turn into a big sanctions violation. This $3 million penalty against Microsoft for instances where they supplied software and services to people in embargoed locations. For companies that are providing software as a service or other services that they distribute over the internet, it's just incredibly critical that you do IP address tracking and geolocation blocking. People from Iran, Cuba, all these markets, if they are dialing in with an IP address from one of those sanctioned countries, OFAC expects you to have some measures in place with your IT department to prevent that access. And then over here, April 25th, $508 million penalty against British American Tobacco. This was British American Tobacco using the US financial system over a 7-year period to route payments related to their operations in North Korea. And so this was an incredibly large penalty. Then also the BIS Office of Anti-Boycott Compliance, they had announced in 2022 they were going to be very aggressive in anti-boycott enforcement, and we definitely saw that in 2023. There were 5 published enforcement actions ranging between $44,750 and $283,000 in penalties. The anti-boycott restrictions are kind of easy to overlook. They're very complicated. Basically, any agreement to cooperate with a foreign boycott or participation in a foreign boycott can violate these regulations. In many instances, if you simply receive a boycott request, you're required to report your receipt of that request to BIS, and they're always very fact-specific. Things like it's prohibited to say that your goods are not of Israeli origin, but it's permissible to say that your goods are US origin. So a lot of it depends on how this language is phrased. Unfortunately, if this language just shows up in a contract and is completely boilerplate, and your counterparty has no intention to impose any sort of boycott against Israel and it's just left over in an old version of their contract, that can still be a receipt of boycott language that can trigger these reporting obligations. So it's something that a lot of companies have kind of put on the lower end of their compliance priorities, but we're seeing a lot more enforcement in this area. So it's something to definitely be on the lookout for in 2024. Russia also saw many developments during 2023. Just to summarize the Russia sanctions at a very high level, OFAC has placed an incredible number of banks, oligarchs, and operating companies in Russia on its SDN list. And with OFAC's 50% ownership rule, what that means is any subsidiaries in which any one or more of those SDNs have an ownership interest of 50% or greater, they are also subject to all these blocking sanctions. Because these oligarchs, these banks, these other key operating companies control such a large portion of Russia's economy, that means it is just incredibly difficult to find a transaction partner in Russia that isn't somehow subject to these sanctions or dependent on a bank that is subject to these sanctions to receive or send any payment for those transactions. Additionally, with the export controls. Any item that's classified under an export control classification number is going to require a license to go to Russia. Additionally, there are all kinds of EAR 99 items that normally wouldn't require a license to go to Russia, but they've now published these supplements number 4, 5, and 6 that impose export licensing requirements for all these EAR 99 items. And then also just a wide variety of services are also prohibited for export to Russia. Examples here are accounting, trust and corporate formation, and management consulting services. So to follow up more on those export restrictions that apply to EAR 99 items for Russia, and I should also say anything that's going to require a license to go to Russia is also going to require a license to go to Belarus. But supplement number 4, this just lists a very wide variety of manufacturing equipment, heating, cooling, ventilation, and filtration equipment, trucks, trailers, heavy machinery, engines, motors, generators, control panels, and then any other components, parts, or accessories that might not be individually listed on supplement number 4, but if they are modified or designed for one of those supplement number 4 items, those specially modified components can require export licensing to go to Russia. So what this means is you might have a spare part for some sort of heating or ventilation system, and you think it's completely harmless. But chances are that there's a factory somewhere in Russia that is just desperate to get that spare part, that common EAR 99 item, to continue their operations. So we've seen a lot of diversion attempts, people trying to get these very common EAR 99 items over to Russia. Supplement number 5, we also have tobacco and alcohol products, common appliances. These are, the title to supplement number 5 is luxury items, but it actually captures a lot of just common everyday stuff. And then supplement number 6, this requires licensing to send a variety of chemical and biological production and testing equipment to Russia. These are items, many of them are just commonly used in delivering normal medical care, but they also could possibly be repurposed to use for producing or developing chemical and biological weapons. So for that reason, BIS is now requiring export licensing to send a lot of these commonly used chemical and medical testing devices to Russia. And as I said, the bad actors have kind of figured out that the sanctions on Russia are so comprehensive. No one's really trying to just order something for Russia anymore when they know it's export prohibited. What has sprung up are a bunch of diversion and transshipment networks. BIS and OFAC have listed these 14 different countries, which they all consider to be high risk countries for diversion and re-export to Russia. I'm not going to read every country on this slide, but I can tell you from the clients that we deal with, both Turkey and UAE are coming up a lot, where we are seeing these suspicious orders that our clients are receiving out of Turkey and UAE. And when you look at it a little closely, it starts to look very much like an attempt to evade the Russia sanctions and buy something for Turkey and then re-export it to Russia. And that would be a violation under these laws. They all prohibit re-export transactions in the same way that they prohibit direct exports. Some red flags that BIS and OFAC have advised people to look out for with all these different Russia export diversions. If it involves any of those different identified transshipment countries, if this customer is submitting an order and they have very little or no web presence, if this customer is going to be asking to use a third party to make payments, that suggests somehow that they can't send their own payment, or that they are headquartered in Russia, and because of the Russia banking restrictions, they can't get the payment out of the account they would normally use. If they're asking for an atypical shipping route, if they're telling you that they want to buy this for one country, but asking you to send it to a warehouse in Turkey for no apparent reason, it's very easy to get goods from Turkey into Russia. That could be a red flag. Another one is if you have a brand new customer who's never reached out to you, or additionally, if this is a customer where you can't find any record that they even existed before February of 2022, What that suggests is that this is some sort of shell company that someone has formed just for the purpose of procuring these goods to then divert them to Russia. And even with your existing customers, if you have a customer that you were doing business with before Russia invaded Ukraine in February of 2022, but now they're coming to you trying to buy new products that they never purchased before, or quantities which are inconsistent with their prior order histories, what that suggests is that someone from one of these procurement networks may have reached out to them, and knowing that they have an in to obtain your goods or services, are asking them to place an order on their behalf for eventual re-export to Russia. So if you see some of those orders from existing customers for products or quantities which are inconsistent with prior order histories, that can also be a Russia diversion red flag. On the OFAC side, OFAC has issued several general licenses that authorize transactions with Russia relating to exporting agricultural commodities, agricultural equipment, medicine, medical devices, replacement parts, components, software updates for those medical devices, and also humanitarian activities. Those OFAC general licenses can get around some of the SDN designations. They can get around some of the other blanket services prohibitions for Russia. However, they do not authorize exports under the Export Administration regulations. So what we see is for farming equipment in particular, a lot of those tractors, a lot of those spare parts, they're also on supplement number 4. So even though the OFAC general licenses might permit you to send a tractor to a sanctioned farm in Russia, you're still going to have to get a separate BIS export license because those items are on supplement number 4. So if you are considering transactions with Russia involving any of these agricultural commodities, agricultural equipment, medicine, medical devices, it's just very important to look at the transactions very carefully and make sure, one, that it complies with all the terms and conditions under the OFAC license, and then 2, that you have obtained whatever BIS export licenses might be necessary for those transactions. When you have something that's in some of these friendly categories, agricultural commodities, humanitarian activities, BIS has a licensing policy to review on a case-by-case basis, specifically looking at whether or not the transaction would somehow benefit the Russian or the Belarusian government or defense sectors. So you can get these licenses, it is possible, but you just have to review these transactions very carefully. That is Russia. Moving on from Russia, China is another key enforcement target for BIS going forward in 2024. During 2023, the BIS enacted many new export control classification numbers that impose export controls on semiconductors. Some of these new China targeting ECCNs will actually capture semiconductors with fairly available processing power. They also apply to electronic assemblies that feature any of these ECCNs, some of which can be fairly common. So if you have electronic items you're shipping to China, it's just very important to know what kind of semiconductors they have in them, what sort of processing power those semiconductors have, and if they might be caught under any of these new ECCNs. We also, BIS imposed many new export controls relating to semiconductor manufacturing equipment, also semiconductor manufacturing materials. So BIS is really trying very hard to restrict the supply of not just these semiconductors to China, but any sort of production equipment or software or other technology that China could use to produce its own semiconductors. In many instances, depending on the ECCN classification, if you have items captured under those new ECCNs, that's going to require licensing to go to China. BIS also added several restrictions that, depending on the facts and circumstances, can also outright prohibit shipping EAR 99 items, so anything subject to the EAR, to semiconductor production facilities in China if they're producing semiconductors which meet or exceed certain processing capabilities. So depending on the customer you're selling to in China, if they're in the semiconductor fabrication industry, it's just really important to know what chips they're producing, what those chips capabilities are, because potentially if they are producing these chips on the fairly high end, you can even require licenses to send them EAR 99 items. And the different electronics engineers I've talked to will tell you that in this category of goods that trigger those EAR 99 restrictions, that there aren't many foundries that are currently producing chips at that level. However, expecting that technology is going to continue to advance in the near future, it's also possible that more and more semiconductor fabrication facilities in China could achieve that production capability. So this is something where you just have to be constantly monitoring these customers and being aware what kind of chips they're producing and if they're going to trigger these restrictions. Then there's a third category where we have new export controls that apply to activities performed by U.S. persons. Normally, we see that the OFAC sanctions cover services and activities. The BIS sanctions cover physical commodities, software, and design drawings. There's some overlap now where if you have one of those semiconductor fabrication facilities, depending on the level of sophistication of the chips they're producing, the EAR will now prohibit U.S. persons from performing activities to support any foreign supply of foreign origin items to those same fabrication facilities. So if you're a multinational company and you have U.S. persons and foreign subsidiaries, these restrictions can apply to those transactions that otherwise would have just completely foreign origin content and no U.S. person involvement. Another China-specific item on the horizon, Executive Order 14105. This is going to restrict outbound enforcement in China. Right now, we only have an advanced notice of proposed rulemaking. Nothing here has become finalized, but based on what was published in that advanced notice of proposed rulemaking, the Treasury Department is forecasting that they're going to be outright prohibiting U.S. persons from making high-risk investments in China related to certain investments in semiconductors and microelectronics, quantum information technologies, and artificial intelligence systems. And then so there's going to be one category of investments in China that are going to be outright prohibited. Then there's going to be a second category of investments that will be permissible, but will be subject to an advanced notification requirement, where U.S. companies looking to make investments in some of these sectors in China might be required to first notify the Treasury Department. And we don't know where that's going. We haven't seen a final rule. They're still evaluating everything they received during that 45-day comment period, but we are expecting that this will become final during 2024. For Venezuela, historically, OFAC sanctions, I shouldn't say historically, but for the past several years, OFAC sanctions have prohibited U.S. persons from transacting with the government of Venezuela. With Venezuela being a socialist country, that definition of government of Venezuela is very broad. It captures a lot of state-owned companies that you or I might think of as being a private company, but with the way structures work in Venezuela, these are controlled by the government. Then U.S. persons are prohibited from transacting with those state-owned companies. In October of 2023, OFAC reached an agreement with Venezuela in exchange for the Maduro regime agreeing to conduct fair, independent elections in the next election cycle. OFAC has agreed to relax some of the sanctions against Venezuela. There's one general license which now authorizes limited transactions with the Venezuela oil and gas sector, and that specifically includes transactions with PDVSA, which is the large state-owned oil company in Venezuela, and then another general license which authorizes U.S. persons to conduct transactions with Minervan, which is a large state-owned gold mine in Venezuela. These are only general licenses. OFAC could revoke them at any time. So we've been telling clients to be very careful about trying to set up long-term transactions with these two sectors that are authorized under these general licenses, and also many banks in Venezuela are still sanctioned. So if you're looking at a transaction with either PDVSA or Minerven that might be authorized under these two general licenses, you also have to look at those payment details very carefully to make sure whatever banks are going to be receiving and sending payments in those transactions are not subject to sanctions. For Israel and Palestine, OFAC had already designated Hamas as an SDN prior to the October 7th, 2023 terrorist attacks against Israel. With Hamas controlling the Palestinian Authority, that can create some challenges as far as trying to deliver humanitarian aid to Palestine. If you have to go through the Palestinian Authority to deliver that humanitarian aid, there are different OFAC general licenses which are available. Another thing to consider, licensing transactions with Israel and Palestine. Under the EAR, Gaza and the West Bank are a part of Israel. So you have to consider if something would require an export license to go to Israel, it will also require an export license to go to Gaza and the West Bank. There are OFAC general licenses available for providing humanitarian aid. BIS has set up a hotline to provide expedited processing for licenses related to Israel. Those are available, but one of the key things here is it's very important to carefully screen all parties in any transactions with Israel or Palestine against denied parties lists. OFAC has become very aggressive in trying to add different facilitators, financial networks supporting Hamas to the SDN list. They're adding more and more persons to the SDN list every day. So any transaction in this part of the world just has to be screened very carefully, and that should include owners, other people affiliated with those transactions, to make sure you're screening every possible involved party. Sudan was also previously subject to a complete embargo. In April of 2023. The Sudanese Armed Forces and the Rapid Support Forces instigated military conflict in Sudan, which is interfering with their transition to a democratic government. For now, OFAC has not reimposed the complete embargo blanket sanctions against Sudan, but they have become even more active in adding different entities, organizations, government officials in Sudan to the SDN list. So while Sudan is still not reverted back to a complete embargo, there is just an increasing risk that people you're seeking to do business with in Sudan are either on the SDN list or owned or otherwise affiliated with persons on the SDN list. So this going forward, which is very important in 2024, to be screening all your transaction parties in Sudan against the SDN list. That is it on the export side. And we have finished with 10 minutes left for questions, if anyone has anything you would like to go over.
It's quite a group.
Yeah, not seeing any questions. I know it's the after lunch lull, you know. Hopefully we didn't put you to sleep.
I think everything was just so crystal clear, and the updates were just, you know, everybody just got it right off the bat. So
Good. Well, we appreciate that. Well, just a reminder, I don't know, Joe, do you want to, I was just going to close us off, but thank everyone for joining us today. We hope the information was helpful. And not to worry, the slides will be available to you and sent to you tomorrow. So I know there was a lot of information here, but we tried to give you an overview of 2023. We also have a year in review 2023 article and outlook for 2024. So if you haven't seen that, it's available. We have a very active blog, internationaltradeinsights.com. So feel free to look there. And just a reminder that this program is approved for legal education hours, CLE hours. We'll be sending you an email tomorrow, which will contain a certificate of attendance, sign in for CLE, a program survey, and a copy of the reporting, as well as a PDF of these slides. So that concludes our webinar, and thank you so much for your time and for joining us.
Yep, and on the Honeywell side, thank you to the Husch Blackwell team for presenting really helpful information. And if anybody on the Honeywell side has further questions, feel free to reach out to the Husch Blackwell team. Of course, you can always reach out to the litigation COE, and we can help connect you with any of the experts, or if you have further questions, we can certainly help with that as well.
Great, thanks, Chris. Have a good
Thank
day,
you all.
everyone.
All
Thank
right,
you.
thanks.
Everyone,
Take care.
Thank you.